may be seated. Oh, okay. You didn't want to open court all over again.
You want to do it a double header? Sure. You're not paid enough to do that twice?
I'm struggling with a cold, as you can tell. Our next case is 23-15-15, and counsel for the appellant, when you're ready.
May it please the court. My name is Ezekiel Lugo, and I represent the appellants, Cameron and Kenneth Garrow. At this point, I would like to reserve 5 minutes for rebuttal. This morning, we submit that the trial court erred for 4 reasons. First, it granted a directed verdict on causation. Second, it struck the defendant's sole expert on the claimed traumatic brain injury.
You speak up a little, or maybe pull the microphone closer to you.
Third, the trial court granted additor as to portions of the damages awarded by the jury. And fourth, the trial court refused to allow a new trial on all issues. The appellants respectfully request that the court reverse and remand for a new trial on all issues, or at a minimum, entry of a judgment consistent with the jury's verdict. Turning to the first issue, the directed verdict on causation. The standard of review is important for this issue. It is de novo, but the appellate court applies the same standard as the trial court, and that requires several things. First, the movement has to accept the facts submitted or relied upon by the non-movement as true, and the trial court has to review the evidence and all reasonable inferences therefrom in the light most favorable to the non-moving party. On the issue of causation, the directed verdict, the motion for directed verdict took a 2-part process. First, there was a motion for directed verdict on causation of an injury. The evidence submitted by or relied upon by the plaintiff focused on the neck injury, but at the end, when the judge made her ruling, she left it vague and just relied on a non-specific injury. The second part focused on the claimed traumatic brain injury. And that's what led the judge to enter the directed verdict on the fact that the accident caused a traumatic brain injury that resulted in a jury instruction that the jury had to accept that there had been a traumatic brain injury. We challenged both issues. As to the neck, there was evidence in the record. The emergency room records included an x-ray that noted mild arthritic changes in the neck, and that's on page 2588 of the record. As to the brain, again, the emergency room records reflected that there was a neurological assessment conducted on the date of the accident.
Well, let me ask counsel, if a plaintiff is involved in an accident and goes and gets medical treatment, and the defense expert concedes that that's not an unreasonable thing for a plaintiff to have done, a person to have done, doesn't that get past the causation issue? I mean, in other words, they may not get intangible damages because there's no permanency in a car accident case, but I mean, they've incurred some expense caused by somebody else. That's causation. The jury doesn't have the ability to come back and say there's no causation whatsoever because the economic damages were not caused by the accident.
Respectfully, Judge Lambert, the answer to that is that the jury can still disregard it if there is evidence in the record that would allow it to disregard that testimony, and that includes evidence, lay testimony that would dispute that there was an injury that occurred, medical records disputing causation, evidence that there was a lack of candor by the plaintiff to the treaters, and evidence that would impeach the expert testimony.
Forget about the brain part, about the migraines and all that, but I'm just the actual neck and shoulder. I mean, so you're at the accident scene, you said, I'm fine, but then as the day wears on or the next morning, they want to go get checked out because they're in some pain. And they do that. And the defense expert says that's not an unreasonable thing to do. And the plaintiff says, that's why I went, because I was hurt in the accident. So all the evidence to the jury is at least those initial expenses are caused by the accident from both sides. How is that not a directed verdict scenario? Again, permanency is still an issue. They could find no permanent injury. You got checked out, you're fine. You got some bills. Defendant should pay that, but that's fine.
In the context of this case, Your Honor, the testimony from the defense expert was that there was no objective evidence that would support the subjective complaints. He testified, like some of the plaintiff's treaters, that they relied on the subjective medical history that was relied upon or provided by the plaintiff. So that calls into question, that allows the jury to reject that testimony if they reject the plaintiff's testimony on credibility grounds. And that's why it's important to look at the totality of the evidence. If there is evidence that the plaintiff has not been completely forthcoming with her doctors in the course of seeking medical treatment for the claimed accident, that should allow the jury to disregard the testimony that is based on her subjective reports to the doctors. In this case, there's one clear example where she was not completely forthcoming. When she saw Dr. Gandhi, he asked her the paperwork he provided on the front end, asked her whether she had a prior history of falls, loss of consciousness, or head injuries, and she said no, when in fact there had been prior episodes where Miss Antonietta had loss of consciousness, had fallen, and had injured her head. She had a long-standing history of low blood pressure and anemia, and she testified that the symptoms she was feeling now were similar to the symptoms she had before the accident that were related to that low blood pressure.
How about if we jump ahead to the more, what I see as the more interesting stuff here. The issue about providing the information to Dr. Demery. And I understand your position is, well, he didn't change his opinion. His opinion was still his opinion. But I mean, the plaintiff's position is, well, you know, we wanted to basically tell the jury, you know, his opinion is based upon a lack of information in comparison to the plaintiff's experts testifying, and that the morning of his testimony, he now gets supplied all the missing information, so that defeats my argument as the plaintiff's counsel to the jury saying, you know, he made his opinion based on a lack of information, and that's not fair that this happens the morning of, you know, the guy's testimony. And that's kind of Binger related. It's not technically a Binger thing, and I don't think it actually technically violates the court order that talks about you have to disclose if there's a change in the opinion. But I mean, that still seems to be troubled the trial judge, saying that's not how we should have the conduct of trials, and here's the sanction. Could you address that?
Yes, Your Honor. So that issue is related to striking the entire testimony of Dr. Demery,
Right.
including when he testified on direct and he gave his two opinions and he related them to the jury without objection. So the judge relied on that fact, which defense counsel admitted that this information had been provided, to strike the entire testimony, including the opinions that the plaintiff was already aware of and had known long before trial. So that makes it different from the cases that they're relying on in the trial court and on appeal. And Judge Lambert, you are correct. This is not a straight or a direct Binger issue. This comes from the cases that have extended Binger to the situation where there has been a witness that is disclosed, but there's either a new opinion that is rendered at trial, which we don't have here, and those cases include Office Depot versus Miller, which is the case that was cited in the pretrial order, Suarez-Burgos from the 4th District Court of Appeal. And those two cases dealt with a new opinion. In the other situation where Binger has been applied to disregard the expert's testimony is situations where the expert is disclosed for one purpose but is used for something else. We don't have that here again. Those cases include Tetrol, decided by this court, where the expert was disclosed as being the person who read the x-rays at the ER, and then at trial his scope of testimony morphs into now he's a neuropsychologist or neurologist, neuroradiologist expert who's going to testify about post-accident, post-suit MRIs. That was improper. In the acquisition case that was cited by my opponent, the witness was disclosed a week before trial, not what we have here. In the Agrofollajes case from the 3rd District Court of Appeal is a case where the witness was limited to rebuttal of a defense witness that was not called. And then that witness was allowed to render an opinion on other matters that were not relating to rebuttal of the witness. So the case law that is available that would allow the trial judge to strike the witness did not fit in this situation. There was no violation of what the actual pretrial order required, which was disclosure of a new opinion.
Let me ask you, Mr. Lugo, about that. And I've got the order, a CME order in front of me, and I also appreciate what Judge Lambert just said about it doesn't violate the express language, and I know I don't sound like a Federalist when I say this, but it seems to me it violates the spirit of the order when it says any changes of opinions or conclusions based on new information. We have new information, so in a sense, even though it's the same opinion, the opinion has been enhanced by the provision of new information. So is that not a violation of the court's order? And at the very least, shouldn't counsel have told the opposing counsel about what had happened?
Your Honor, it was not a violation of the spirit of the order. The entire paragraph has to be taken into account, and there is a case cited there, Office Depot versus Miller, where the focus was on the new opinion that the expert had rendered. Now, I was not trial counsel, and I don't condone what happened here in this case, but it was not something that deprived the plaintiff of the ability to still conduct that cross-examination.
Let me ask you about that too. I don't see how the court could have put the genie back in the proverbial bottle, and I appreciate and am very much behind the first DCA case you cite in your brief that said, okay, well the solution here was just to limit the opinions to the report. I get that. That Allstate case, I'm in full accord with that. I think that's a nice way as sort of a fallback. But the problem here is you've got the plaintiff's attorney on opening statement saying we've got a predicate problem here. We have a credibility problem with this expert when you evaluate these experts because they don't have a similar corpus of information. So I just don't see how the court could have set that right by limiting this expert's opinions to his report. So explain to me how this could have been set right.
Well, Your Honor, that problem was still there because the expert had still rendered the opinion at a point when he did not have those records. So that point, that sort of impeachment or challenge to the expert's credibility was still available to the plaintiff. They could still point to the report and tell the jury, or at least elicit from the expert, that he rendered the opinion he rendered absent that information.
Help me, Mr. Lugo, we're in real time now at trial. What does the court tell the jury? How does the court disregard the entire direct at that point in time? What does the court say to the jury to get them to disregard that and then a do-over as to the report?
Well, Judge, the jury didn't have to disregard the entire testimony on direct. Nothing came out on direct about the expert having reviewed anything other than what was in the report. This happened into the cross-examination when a question was asked in the context of a pretrial ruling saying that the defense experts are going to be limited to what's in the report. Knowing that, there was a question asked on cross-examination, well, what did you do to prepare for your trial testimony today? And that's when the answer came to the question about having reviewed the plaintiff's deposition. The judge could have instructed the jury to disregard that answer, and the judge could have instructed the expert to limit his testimony to what's contained in his report and what he reviewed when he issued that report. And I've seen that sort of testimony, and then on recross or redirect, the attorney that calls the witness can try to rehabilitate the witness by asking hypotheticals based on the information that is in that additional medical report or the information that was testified upon by the plaintiff. So the information can come out in some way anyways. And
And I would just leave all of us with, that's fairly surreal. That's like a parallel universe. Disregard the fact that you just looked at all this stuff and put yourself back in the shoes of the person you were when you generated this report, even though the jury has heard him say the very same thing based on the new information. So I just have trouble understanding how you can unring that bell. But you're telling me it can happen.
Yes, Your Honor, that's our position. There was a way to adjust the cross-examination and to instruct the witness.
Your meter's running. Can I ask you about the editor for a
Yes,
little
sure.
bit? It's an abuse of discretion standard that you agree it's an abuse of discretion standard, whether the trial judge abused the discretion. The plain language of the 768.043 says, send it back for a trial on damages only, and the trial judge in her order specifically found it was not a compromise verdict. So I know you have those last two issues kind of co-joined. Tell me how it is that we set aside the editor or set aside the new trial front and the editor issue.
Your Honor, the one thing to look at is the language at the top of that editor statute, and it wasn't 043, the one that was cited here, it was 47, the general editor statute, and that presumed that there's a valid verdict or there's no dispute as to liability. The case law itself has explained that a new trial limited to damages is appropriate only where the evidence of liability is undisputed. Where the evidence is conflicting and the jury could have reached a verdict in a manner consistent with the evidence, it is error for the trial court to veto the jury verdict by granting a motion for editor. And that was this court in Moore versus Perry, 944 Southern 2nd, 1155. And our position is that's what we have here. There was a dispute about liability. All these issues about
So, I mean, the plain language says what it says, and I mean, they don't ever give me a Federalist hat for good reason, but let's use that for a second. The plain language says for damages only, and the verbiage used in case law is hotly contested. Liability is hotly contested. I mean, it sounds like you're saying unless liability is conceded, it therefore ergo is hotly contested. So anytime there's an editor that's rejected, it has to be a new trial on all issues.
when the judge makes a finding that there's an inadequate verdict and the issue of liability is contested by the evidence and the parties, that creates a suspicion that there has been a compromised verdict. None of the cases require proof that there is a compromised verdict.
And the indicia of the compromised verdict, I mean, if they came back 60-40 on liability, that would tend to be suggesting it's not compromised, but when it's 100% with an inadequate verdict on damages, that suggests, well, we found you liable, but we didn't hit you too hard with the damage.
The focus is not solely on what the jury finds, it's on what the parties dispute and what the evidence disputes. And in this case, liability was disputed from day one, still being disputed on appeal. We do not agree with that directed verdict on causation, and I'll reserve the remainder of my time for rebuttal.
Mr. Markman, I presume.
Yes, Your Honor. Jeremy Markman for the appellees, Mr. and Mrs. Antonetta. May it please the court? All right. The bell could not have been rung when Dr. Demery testified based upon undisclosed foundational evidence. There were numerous violations of court order leading up to trial that the trial court there found that the actions of defense counsel in this case were intentional, prejudicial, and incurable. And the intentional portion of it included an assessment under the Binger factors of analysis of the defense counsel's actions in late disclosing the expert, in violating the discovery deadline, in violating the expert disclosure deadline, in violating the order that you referred to, the 1.360 report order, at least the spirit of that order, if not the substance of that order.
How was the substance violated if the substance of the opinion didn't change? I mean, I know you talk about it was the expert was disclosed a few days past the deadline, but that really is for me, that is a non-factor here. It wasn't like the trial was 2 days later. I mean, there was enough time, and obviously the guy was deposed. So, I mean, the order says if you change the opinion, you got to let the other side know. Their position is the opinion didn't change. I get what you're saying is that, well, you know, you can't feed them all the information so they can fill in the blanks, or they can buttress their opinion saying, well, I've looked at everything that they've looked to and my opinion hasn't changed. That strikes me as unfair. That's the spirit of the order. But actual, you know, when you're going to the sanction of striking somebody as an expert witness, that's a severe sanction. I think you'd agree.
I agree it's a severe sanction, and I agree, and I think that the case law, the Binger progeny on this, is exactly why these actions should be upheld and Dr. Demery should be excluded. Even if we look at the substance of the opinion, the conclusion of the opinion in the report, the 1.360 report by Dr. Demery, focused on documents, focused on what evidence he reviewed, because the conclusion of his opinion was no records indicate a TBI of any magnitude. The reason that he concluded that no records indicate is because he hadn't looked at the records of the neuropsychologist treating that indicated a TBI of some magnitude. And therefore, the focus of the 1.360 report and the conclusion of the opinion of Dr. Demery were that no records indicated a TBI. And then when he went to go testify, he changed his opinion from no records indicate, because he had just looked at the records those morning and clearly records indicated TBI of some magnitude, and changed the opinion from no records indicate to there's no neurocognitive impairment due to a TBI.
Was that the argument you made, though, to the, I don't know if it was you, but the plaintiff's attorney made to the trial judge below, saying, look, he has changed his opinion?
The argument was that he had changed his opinion. The particulars, and I'll concede to you, Judge Lambert, the particulars with regard to the no records indicated versus a neurocognitive impairment are not clear in the arguments at trial. But the argument was that he had changed his opinion. Not only had he changed his opinion, but the judge found not only a change in opinion, but bolstering of the opinion. And if we look at what, Judge Jay, what you were talking about, when you take an opinion, even if he hadn't changed his opinion, and then bolster it with records that were just disclosed that morning at trial, under Grau versus Branham, if you recall that case out of the 4th DCA, that was two plaintiffs treating doctors that had done examinations of the plaintiff during trial. The first one got away with it and changed their opinion. The second one did it over the weekend and did not change their opinion. And both were stricken. And the reason both were stricken is that the 4th DCA specifically said that the second doctor bolstered their opinion, just like this trial court said that Dr. Demery bolstered his opinion, and it was improper to do a mid-trial examination, which was a complete surprise to the plaintiff. And the other factor on this is that they didn't tell opposing counsel at all that they were doing this stuff all the way up until 7:45 the night before, and specifically hid it, even though they knew in the opening statement that the focus was that plaintiff's counsel asked the jury to focus on the foundation for the expert's opinion. And then they go and provide that foundation during trial. That's why these sanctions are appropriate. And so such action should be upheld. Otherwise, what we've got is we've got sort of the Wild West on we can provide anything to any expert as long as they conclude, because Dr. Demery did say, my opinion didn't change. What the court found was, based upon their analysis of it, that it did change in that it was bolstered. And when we look at the particular wording and the semantic wording of that, the focus of the 1.360 report was on records. And the fact that records had been supplemented mid-trial meant that it did change.
If Dr. Demery's testimony was allowed, would that would affect your argument in response to issue 1 raised by your opponent, because that would have raised an issue about whether your client suffered any brain injury as a result of this accident? It would have been a factual question for the jury to resolve.
Yeah, if Dr. Demery was allowed to testify, then realistically, I mean, what defense counsel said in his opening statement is Dr. Demery is going to say there's no TBI. What Dr. Demery actually said during direct was there's no neurocognitive impairment due to a TBI. He never equivocally said there's no TBI. But For the purpose of this, Judge Lambert, for concession, realistically, that might have been enough in order to...
Does it even matter if there was already if there's a directed verdict? There's evidence that she sustained some damage from this action. She got medical treatment, incurred medical bills. Whether there was going to be a permanency finding, and that was up for the jury. I mean, it's still, as a matter of law, she was entitled to some money for economic damages, assuming that the jury didn't find 100% fault upon her for the accident.
Absolutely correct.
I mean, wouldn't it be reversible for them to award her zero, finding that the causation was by the defendant, but your client gets no money?
Correct. It would be reversible.
And that directed verdict took that step out of the equation. It was just, okay, what is the reasonable economic expense related to this car accident caused by whatever you find Mr. Garrow, the junior, did?
Yes, and that is essentially what the purpose of directed verdict is, to take that out of the hands of the jury so that the jury doesn't get it wrong and award zero damages when causation has been established by the undisputed facts and no reasonable jury could find otherwise that then the economic damages were caused by the motor vehicle
Didn't the
accident.
defense expert who was allowed to testify, didn't he concede that it was not unreasonable for your client to seek some medical care after this accident?
Yes, and in fact, not only did he say it was reasonable for Ms. Antonetta to seek medical care after this accident, but he conceded that it was reasonable. All of the medical care and treatment was reasonable all the way up through trial. The only thing he contested was whether or not it was permanent and whether or not all of the medical care and treatment was caused by or related to the accident. But not only did he concede to the emergency room treatment, he conceded to the chiropractic treatment, he conceded to the radiological treatment, all the way up to a certain arbitrary point in time where he cut off causation. So in that case, a directed verdict on causation is absolutely appropriate, and the fact that the trial judge granted the directed verdict in addition to the one with regard to generally causation based upon the neck injury that was conceded by the defense doctor, it had no import with regard to this issue of directed verdict to also grant a directed verdict with regard to a concussion, also known as a mild traumatic brain injury. In fact, the defense was able to argue, and did argue during closing, that that brain injury that was provided a directed verdict on went away by the time she got to the emergency room later that day. So it had no import on this with regard to what the jury could find on that. The jury obviously disagreed that she was injured as a result of the accident and also found permanency. I would also put in here that it appeared in the initial brief on this that appellant waived the issue of directed verdict on causation on the neck injury and was focusing solely on the one on the mild traumatic brain injury. But either way, it has no import because the directed verdict on the neck injury was conceded essentially, and there was undisputed facts.
What is your response to Mr. Lugo's argument that, as to the issue of the additor, that if the liability is hotly contested, that when the additor is rejected, that there's case law from this court that says it should be sent back for a trial on all issues?
I think the reading of the case law, well, let's start with the fact that the plain language and the rules of construction tell us that the plain language governs under both Florida Rule of Civil Procedure 1.535C as well as Section 76874, that where it is the appellant's option to either accept the additure or to elect a trial on damages only. Now, there's a judicially constructed case law that says that where issues are hotly contested, then this court has previously found that when issues are hotly contested, you can have a trial on all issues. The issue there for this court is that hotly contested isn't defined. And that's a problem because the appellant's argument is that hotly contested should be, we don't concede to liability, we don't concede to causation, even if there's no evidence of anything other than the defendant in this case being liable or causation being established. So that can't be the standard. Hotly contested has to be something, and it has to be based upon the evidence. So even on the issue of liability, we've got the third driver that was hit. Remember, this was a 3-car accident. All 3 cars were totaled. The third driver said that the defendant was liable. The plaintiff said the defendant was liable. An independent witness nurse said the plaintiff was liable. And importantly, the defendant driver, the kid, said that he was responsible for the accident. He tried to push off some liability by saying that that she was too far out and then entered the intersection on a yellow light. But it's perfectly legal to enter an intersection on a yellow light. What's not legal is to turn left on a yellow light when there's somebody approaching in the intersection like Mrs. Antonetta was. So there really is no contested issue with regard to liability. There's no contested issue with regard to causation. And there's also no contested issue substantially with regard to any other issues other than this court should be following the plain language of 76874 and Rule 1.535.
Why is it 768.74, not 043? Isn't that involved, isn't that specific to motor vehicle accidents?
It is. It is.
Why wouldn't we apply the more specific statute?
Yeah, I would concede yes. Okay.
Is there any difference if we apply either or?
I don't think the effect of that is, if we look way back on what the creation was for additure, because remititure had existed before additure, and therefore there was a specific statute with regard to motor vehicle accidents. I'd agree, but either way, it's the appellant electing a trial on damages only by rejecting additure, or the adverse party electing a trial.
Do you agree that trial judges should not act as the 7th juror to veto jury verdicts?
Of course, and that's...
Well, let me ask, in the context of what, and maybe correct me if I'm misreading the record, this judge, when she granted additure, she basically said, for round 2, here's the floor of damages for the additor damages I've awarded. Let's assume she's not the judge there at retrial for whatever reason. She quit, whatever. And the judge who's presiding over it hears the same evidence and doesn't have the same visceral reaction to the jury award that Judge Fields, I guess?
Yes.
And is the successor judge who's hearing the evidence, not just reading a cold record, here's the evidence, that judge is bound by Judge Fields' sense of shocking to the consciousness of the court?
No, it's not that the new judge would be bound by Judge Fields' shocking view.
No, my point, so if the jury comes back with the identical numbers, round 2 in front of Judge Smith, whoever.
Correct.
And is Judge Smith go, well, you know what? In 2022 or 21, Judge Fields says it's got to be this, so I'm doubling down, added her again.
I think that judge makes an independent determination based upon the evidence that they see at the time, whether or not that shocks their conscience.
And that's why I'm wondering about the floor that she's setting. Did she set a floor? Is that what you're understanding?
Yeah, ultimately she set a floor on when we had the motions for rehearing on that. She set a floor as to what the minimum amount of damages could be awarded, because it was proven by preponderance of the evidence that those minimum amount of damages were awarded, and that at the very least would be a minimum that would not necessarily shock the conscience of any new judge that comes up.
So she's binding the successor judge.
She's binding. She is. She's attempting
to do that. Can she realistically do that?
Sure, just like a jury comes back, and it's not the judge that's binding it. She's not binding the successor judge to her additure numbers. She's binding the successor judge to the jury's numbers. The jury has to come back.
The jury got it wrong. These numbers are wrong, but we're going to use them again.
These numbers.
What is the legal basis for that? I mean, that's what she's saying. The jury got it wrong here. The jury got the damages so wrong, I got to change it, or we have a new trial on damages, but we're still going to use those numbers for a reason. And what's the basis for that?
Because the jury got it wrong in that they didn't award enough. And so that's why there's a floor that's been set by the jury that the trial judge recognized.
And what's your best case on that one?
The problem is there isn't a real good case on that.
So there's no case
right.
on that.
Right, there's no case specifically on that.
Well, and I'm looking at the statute, and I'm looking at the rule, and that doesn't exist either place, correct?
That's correct. It does not exist in the rule, the statute, or case law. What it is a determination by the trial judge that accepts the jury finding, just like a jury made a finding with regard to permanency, or just like a jury made a finding in this case with regard to liability. We are accepting the jury's findings because the judge didn't determine that the jury was wrong on those issues. The only thing that the judge determined the jury was wrong was on the measure of damages, in that the damages were not enough, and therefore she's accepting the findings of the jury that that minimum amount that the jury found has to be a floor.
Well, that's not what she did. I mean, if she did that, you may be right, counsel, but what she did is, I reject what the jury did. I'm going to come up with a new number, and I'm going to impose that as the floor.
Yeah, what I would say is...
Correct?
Her new numbers are the floor. I mean, if she tries the case again, you know, then she's saying, okay, look, in my mind, I already said it's got to be at least 100 for future non-economic damages for Mrs. Antonietta.
I think...
And if the jury came back with 60, she'd say, do over.
I think the only way it would be a do-over in that context, even if she is the trial judge below again, would be if the jury didn't reach the floor of what the previous jury had found, because her determination of additure, it was reasoned, it was based upon what the evidence was at the time and the problems that shocked her conscience.
What if Mrs. Antonetti came back at trial 2 and says, you know, I'm feeling really good. I'm fine, you know, I don't know how much this is bothering me anymore, and not for nothing in retrospect, I don't know how much it was bothering me at the first trial.
Then we probably wouldn't have a second trial.
Well, you're in the second trial when she makes that. I mean, you guys are certainly not adverse to that, because part of your scenario here is you had her husband said, don't give me any money.
Well,
which probably was not something that the plaintiff's counsel was hoping to hear when he was testifying, I would hope.
Realistically, that came from a place of, I want to make sure that my family is taken care of, therefore I don't need the money myself. Well, that doesn't mean he's not entitled to it.
Let me segue now that I threw that out. I mean, you know, we bring in jurors from all parts of wherever. They come in, they listen to all of our instructions and, you know, follow the law, apply the evidence, don't listen to what the lawyers say, that's not evidence, et cetera, et cetera. So you got 6 people sitting on the jury, and you hear, I'll call him Jim, I don't want to butcher the last name. James says, I don't want any money. All right, whether you like it or not, that's what he kind of said. I'm paraphrasing it. And the jury hears that, and they're told to apply the evidence, you know, listen to the evidence, and they come back and say, okay, James doesn't want any money, we're not going to give him any future money for loss of future consortium. How is that problematic? How do we tell a jury you're wrong when you did exactly what that plaintiff told you to do?
Given the hypothetical and accepting your paraphrasing of Mr. Antonetta's testimony, the answer is that the jury got it wrong because they didn't follow the evidence on what the damages are.
He told you, I don't want any money. I don't want any money, period.
But the uncontested evidence was that he had suffered consortium damages.
But he can waive it, right? He can say, I mean, I get it if I'm a plaintiff's lawyer going, my goodness, that's not a good thing for me to hear in trial. You know, if that's what you thought about, maybe we could have gotten your case settled out of here. But he says that to the jury, and they do exactly what he tells them. And then the trial judge says, oh my goodness, no, 0 is too low. You get 176.5 based upon 35.3 years or something, when she tells them, and oh, by the way, the mortality tables are not binding upon you, but they apparently bind her in her analysis?
They didn't bind her, they were instructive.
She used them.
She did use them, and they were instructive because there was no evidence contradictory to them. But when we're talking about Mr. Antonetta's testimony, his opinion on how they should use the money or what the jury should look at as important is not the same as what the evidence is with regard to the consortium damages that he had suffered.
Well, you're saying it was uncontested, but he contested it. I mean, he testified. I mean, if it was a statement out of court, I get you, but he was under oath and he said, I want no damages whatsoever.
He didn't say I wasn't hurt. He said, it'd be better for my family to have it. I'm not the one interested in it.
Maybe they did that.
Well, I don't think that's what they did if they followed the evidence based upon what the uncontested damages that he suffered, the consortium damages that he suffered, were introduced to the jury. And I would ask this court to affirm and remand this case back on the sole issues of damages that are outlined in the adjudicature. Thank you, Your Honor.
Thank you.
Okay, Mr. Lugo, you got about 2.5 minutes.
Thank you, Your Honor. May it please the court again, and
Can I ask, did James say that to the jury? I don't want any damages?
that's how the jury could have interpreted
Well, I mean, I
what
don't
he
know
testified
specifically, I'm
about.
not quoting him verbatim, but in essence, that was his.
In essence, Your Honor, and the jury was entitled to rely on that part
That's
of the
evidence
evidence
that they relied upon.
and reject the rest of the evidence. The jury is free to do that, and part of the problem in this case is that the judge prevented the jury from doing that. And it goes to the first point I wanted to make on rebuttal, dealing with the directed verdict. The best case I have for the situation that you keyed on, Judge Lambert, is the Lancheros versus Burke case that was decided by the 6th District Court of Appeal. Very similar situation where the defense expert said, okay, I'm going to concede that based on what the plaintiff is saying, they would be entitled to damages up to this point, which is it's testimony that comes very frequently in these sorts of cases. And the 6th DCA said the jury can disregard that if there is other evidence on which it could find that there was no causation, including the prior medical history before the accident.
Or is there a new court? We got to watch out for them, don't we?
Maybe. But the definition on opinion on point, and it's based on a Florida Supreme Court case, Wald versus Granger, where the Florida Supreme Court said the jury can disregard unrefuted expert testimony as long as there is a basis, including conflicting medical evidence, evidence that impeaches the expert, failure to give complete or accurate prior medical history to the doctor. And that was applied in the case of USAA versus Ray out of the 2nd DCA, which is an old court. And
I'm just kidding about the
you-
6th DCA, because the majority of them came from our court, so.
I
I was
understand.
just saying it tongue-in-cheek, they're very good judges over there.
In the Ray case, there was a directed verdict as to causation of a knee injury, but there was evidence from which the jury could have relied to disregard the expert testimony and render a verdict for the defendant. In both of the situations, the directed verdict was improper and resulted in a new trial. In this case, we have the MRI reports themselves, post-accident, say non-specific, and talk about other potential causes, and Dr. Gorman's testimony, who testified about it not being specific. And the last point I want to make real quick, to refute the point that hotly contested is not defined, it is. This court has defined it. FLNC 220 Southern 3rd at page 1224. You don't look just at the jury, you look at the evidence and the parties' arguments. And with that, we request you reverse and remand.
Thank you very much. We will be in recess.
Thank you both.
All right.